We'll take from that side. Yes. Any
application, my lord.
You?
I have a land tribunal matter.
Yes.
My application connected.
Application.
One index of signature, so item number 21.
21.
Yes.
One minute. Please.
Could it be a lawsuit to release the items when mentioned assistant today?
6 to 21 will release.
Yes.
You have to release. 6 to 20. We will release.
Yes.
When you call, we'll release.
At the time of
Yes.
Leave to LRTT appeal, leave to move on short service on Monday.
Very good. Yes.
I'll give the number.
May I mention, because 6 to 21 will not happen. So number 24, in case it is not called on in the first half, 24, 20, 25, 26, I'm for the appellant. So second half, I may be in scientific.
Just ask someone to mention it. And just inform your other side, Mr. Mitra.
Yes.
Well, application, my lord. Order 41.
No. Order 41, you don't have determination.
16, code number 16.
Different.
Land type one.
Lord, may I be permitted to mention a matter for inclusion under the
What is the matter?
my lord, correction in the Solomon order.
Our order?
My lord.
Recalling of an order inclusion.
Our order?
Yes.
My lord, may I be permitted to mention on order 41, my lord, for inclusion.
We don't have determination order 41 from today.
Justice Sen.
Just said, yes. Okay, here. ওনাকেও তো করতে অ্যাপিল নিয়ে সারাদিন ধরে শুনতে বসে আছে, একটা করে অ্যাপিল নিয়ে
I'm for the respondent.
Right.
And I appear for the writ petitioners, led by Mr. Kaur.
But this was released by the bench of Justice Chakraborty and Justice Chatterjee.
Justice?
Justice Chakraborty and Justice Chatterjee.
Why? What is the can for?
But this is the can one is the stay petition.
This is in connection with what appeal?
But this is an appeal whereby the learned judge has held that the LA case initiated has lapsed. It has been held that the land acquisition proceedings have lapsed. But from that, it is the West Bay HITCO has come up in appeal.
No, this application is for
Stay of the order. Can.
So these appeals are required to be admitted formally, Mr. Bhattacharya?
No.
This was being heard.
This was
At the hearing stage.
The appeal has to be heard.
We'll hear out the appeal tomorrow.
Yes.
We don't have anything else to do.
Yes.
May
All
be
the papers are there.
Can it be Tuesday, my lord, instead of tomorrow?
Any
Appeal along with the application.
But not.
We are eager to take up the matter today, but
Milord, may I just indicate the frivolousness of the appeal, Milord, in one sentence.
no, indicate the frivolousness when you take up the matter.
kindly seize the order under appeal once. Kindly seize the order. Your lordship will kindly seize the order under appeal once. From the memo of appeal.
So much notes were taken by some learned judge.
Yes.
No, by the division bench, probably.
Yes. Kindly seize the order dated
Required hearing. Must require hearing.
October 6, 2023 order. Kindly seize the nature of the order. I'm handing over.
No, we have. Cost title is.
Aero Height Apartment Consultants.
Yes.
There are 20 writ petitioners.
One have any semblance of grievance.
What will be a ground in this?
But the writ petition itself was not maintainable.
And that's
The reason is they are transferees.
So it has been held to be.
It has been held that the land acquisition proceedings have lapsed. Hence, I had to hand over the no objection. But if the petition was not maintainable, because a transferee.
Why is the petition not maintainable?
Because if the transferee cannot challenge the lapse proceeding.
Under which provision cannot challenge?
No, there are judgments which we are relying on.
We will have to hear it. hear it.
Transfer he cannot, well, this point, they have filed an affidavit in the court below, indicating that this is, this
No, it's a
situation.
point, new point of law, I can take it at any
Yeah,
point of time, my lord. It's
They
a
have filed an
independent-
affidavit.
Decide whether it's a point of law. We will have to decide this point. This point. Why frivolous? Yes, since you have heard him. Because of this.
Yes, Milord, Hitco says that Milord, the land acquisition proceeding has not lapsed, where Milord state on affidavit in Milord disclosing documents say it has lapsed. And
Will-
Milord, the appeal is absolutely contrary to their affidavit used Milord before the honorable single judge.
In view of the scope of hearing in the stay application pertains to the merits of the appeal as well, comma, the appeal along with the application be listed for hearing, ought to be listed for hearing. Full stop. On the prayer of learned counsel for the appellant, comma, the matter is adjourned till August 12, 2025, when it will be listed, when the appeal along with the application shall be listed for hearing. At a hearing, Section 5, there is Section 5.
No, my lord, that
allowed.
delay has already been condoned.
Yes.
Morning, be fairly at the position where it reaches. Because on 5 occasions, they have paid for
This may be the only matter also
Very-
to use. We don't-
very.
Right.
Great.
Yes.
My lord, this is a review
Review application.
But then
What order did we pass? Just remind us of the.
Lordship,
Oh, that yes, yes. Now, seeing the council, we remember. Yes, because the sides have changes. Our memory. Yes.
but we change with our respective clients only. It's not like that we change and client.
Definitely not. Definitely not.
Lordship, there is a small defect. In some suit, they made the earlier inquiry officer as a party. And in this suit, they have not made. So probably when I was giving dictation, I have wrongly arrayed that gentleman also as a party.
Which person?
Lordship, pro forma respondent number 2.
2. So we can just direct deletion of his name.
Yes,
It
Lordship.
was not a party in the.
Yes. Kindly delete. And Lordship, another small request to you.
Absolutely yes.
If your Lordship kindly keep it on Monday or Tuesday, because client has partially lost faith on me and they have engaged a senior upon me. So Lordship, my senior.
Then we ensured that we assured him that we will dismiss it, if that is the reason, because of the order.
Just on a lighter tone, I said.
We assured the.
No. Actually, I on a lighter tone, I said. But then my senior is there. If your Lordship kindly keep it on Monday.
Mr. Ali will just direct the name of 2 to be deleted because that's the defect, superfluous, and we'll keep it on Monday then.
Lordship.
Very well. Learned counsel appearing for the petitioner submits that due to bona fide inadvertence, the name of pro forma respondent number 2 has been included. Push up on the prayer of the petitioners. Leave is granted to the learned advocate on record for the petitioners to applicants. Learned advocate on record for the applicants to amend the cause title of the review application by deleting the name of pro forma respondent number 2 during the course of the day. Push up on the prayer of learned counsel for the applicants. Let the matter stand adjourned till August 11, 2025.
I'm deeply.
Please do the correction today itself. Yes.
I'm grateful.
Thanks.
For the appellate, by.
Well, I appeal for the respondent, my lord. This is that matter, my lord, with regard to requisition. Your Lordship had heard it day before yesterday. Mr.
Yes.
Bandyopadhyay was there.
Yes.
Property in Poddarkot, your Lordship had directed. Mr. Bandyopadhyay was saying his client is willing to pay the market rent.
Yes, ma'am.
Uh-huh.
Lordship had directed us to take instructions.
Yes.
I have taken instructions, my lord. My clients are agreeable, my lord, on this proposition, my lord.
So you have you written something to them?
I will.
You have to convey to them. Very well. So when should we
My
keep
lord,
it?
kindly grants 1 week's time, my lord, because we also want to end it up in a very short time and time-bound manner. We have been suffering for 30 years. So if your Lordship
But
kindly keeps it.
given, exchange offers in the
Yes,
weekend,
that is what we'll sit down together, my lord, and
do that. But you also involve yourselves, the council.
Yes, yes,
Otherwise,
yes,
it will
yes.
never happen.
my lord, that is why we want to finish it off, my lord. This
Very well.
matter
Fair
can be
enough.
my lord.
You are for the
I'm for the respondent number 1.
one. Yes. Learned counsel for the respondent number 1 hands over a written instruction to the effect that the respondent number 1 is agreeable to discuss an amicable settlement to the matter with the appellant. Full stop. Next para. uh, while appreciating such fair gesture of the respondent number 1, comma, let the matter stand over till August 14, 1 week.
Some more time, my lord.
Some more
2
time.
weeks, my
2 weeks, we'll give it 2
2
weeks.
my lord.
August 21, 2025,
Yes.
when it will be listed under the same heading. Full stop. It is expected that the parties shall reach an amicable settlement in the meantime.
Grateful.
And in the meantime, stay off the operation, my lord. In the previous order, it was.
Yes, your lordship had directed, but it has not gone down in the
Sorry,
order.
yes,
Also, we have informed
Correct.
the.
The operation of the impugned order shall remain stayed until further orders.
An order dated 21st May 2025.
My lord,
There
can
is
it
only
be
one impugned order.
21st?
Several impugned.
No, no, one.
আজকে দিয়ে দিচ্ছি হ্যাঁ
My lord,
না
stay,
গন্ডান হলে গন্ডান বের
my lord, stay is still until further orders, my lord, or till 21st, my lord.
no
When
no
the
if
matter is
21st by
determined.
any chance something
Alright, because
happens to us and we don't see them
থেকে যাবে।
anything may happen until further orders আচ্ছা until further orders না করে till August 31 2025 or until further order whichever is earlier.
Grateful, my lord.
Grateful.
Item number 4.
In this matter, I am appearing on it.
Yes.
And I appear for the state respondent.
Yes, yes. The doctor, please take your seat. Yes, here, just here. Yes, Mr. Das.
My lord, by 3 deeds, that is on 9/10/2027, 2007, 15/4/2014, and 15/5/2000, by 3 deeds, I have purchased the plot number 117, 2 decimals, and 117/1183, 1 decimals. 117 total area is 3 decimals. Out
Right.
of 3 decimals, I have purchased 2 decimals of land, and 117, that is 1 decimal. On that basis, record of rights.
You have
prepared.
purchased 4/5 decimal of land in 117.
117, 2 decimals of land out of 3 decimals
Acha.
by 3 different deeds.
117 by 1183 is a butter plot carved out of the main 117.
Main 117, that is the 117, 2 decimal, 117, 1183, that is 0, 1 decimals.
Acha.
2 decimal. On that basis, record of rights was prepared, that is 447 and page 48.
All
I
right.
have deed annexed, that is page 11, 23 and 33.
What was your grievance?
My lord, kindly, I am coming one by one. My lord, kindly, for a moment, page 47 and 48, the record of rights. The 2 petitioners,
Yes.
one is Shaktibodo Manna,
Right.
that is plot number 117. He purchased 1 decimals.
Yes.
And next page 48, that is plot number 117, that is the Vishnupada Manna. He purchased 1 decimals out of 3 decimals. That means in plot number 117, 2 decimals of land. And Bhatta plot, that is also 1 decimal, they have also purchased by 2 petitioners. And on that basis, conversion order was passed, that is page 49, page 49. That conversion order was passed in the year 2015, 49.
49 and 50.
49 and 50. That is both the plot number 117 and 117/11 Bhatta plot. That is the 1 decimal, that is total 2 decimals of conversion was made.
Converted to be converted to Vastu.
Converted to Vastu.
Right.
And all of a sudden, in the year of 2018, the Panchayat Samiti, the chairman of the Panchayat Samiti, the respondent number 8, started a construction of a public waiting room in the plot number 117 only.
Yes.
I raised objections before the authority concerned. So without acquiring the plots of land, that
What was the gift deed? Who gave, donated the property, his share? Vishnupad.
coming. That is the one, no, that is the one of the other co-sharer, that is Ananta Mondal.
Ananta.
Ananta Mondal,
When did he transfer?
he gifted his share 19/3/2018. 19/3/2018.
Ananta transferred how much?
That is the 167 square feet in plot number 117 only.
Right.
Out of 3 decimals, I am owner 2 decimals, and Ananta also a owner of 160 decimals, 167 square feet. He had transferred the Panchayat
He transferred his entire portion to
entire portion.
very.
That is
117.
7, that is on 19/3/2018.
Right.
I filed an objection on 22/3/2018 before the authority concerned, that is page 94. For a moment.
Right. Then
So without acquiring land, then I moved an application on that basis, my lord. By the orders of the Honorable Court, one measurement was made in presence of the subdivisional officer and BLR. That measurement report, they have filed their oppositions and annexed it. That is straightway come to the report and the measurement report, page 154. For a moment, it will be clear.
yes.
That is the plot number 117, the bottom portion, that is the plot number 117-1183. In front, that is the Contai Rasulpur Road, that is the north. In the plot number
This
117,
was prepared by a
By the-
surveyor.
by the by the BLRO, that report was filed by the BLRO. That is the notice was
As per order of this court,
this
the single judge.
single judge. Yes.
Right.
Page 152. The notice was issued.
All right. Then
And on that basis, inspection was held in presence of the both parties. And that report was filed, their own report. The in front, that is the Contai Rasulpur Road. And thereafter, plot number 117, that is 3 decimals. And thereafter, the last bottom, that is the plot number 117-1083. They are, according to their own sketch map, they have stated that is the reference in plot number 117, 3 decimal, but actually area is 4086. That is above 3 decimals.
where have they stated 4086?
4086, the area of the map in the bottom, their report reference.
Yes.
And plot number 117-1183, that is 1 decimal, but actual its position is much higher, that is 1096 square feet. But waiting room area, that
But
is
they also state that the area stated in the map in the ROR is 3 decimal.
3
But the
decimals,
total area
but-
in the
but
Mosa map
the-
is
but
total area in the Mosa map is more.
most of that
4086.
physical position. But physical position, sometimes the record of rights and actual position, some difference. For this is in actual record of rights, that is 3 decimal, but it is in physical position much higher. That is 4086, above 3000. For this is in waiting room area, that is constructed 450 square feet on road. That is the very important on road, that is the in front of the Contai Rasulpur Road, that is the PWD road, that is plot number 62.
Yes.
That is plot number 62, he encroached 109 square feet. On plot number 117, 341 square feet. But donated is 167 square feet only.
Yes.
That means that is a crystal clear, he has encroached at least 174 square feet above. This is very interesting, my lord. Thereafter, that is the concrete road, that is the excess area. I am stating the excess area, the concrete road already constructed before my purchase of the land by the authority concerned, by the Panchayat authority, that is used for public purpose. That is concrete road on plot number 117, that is 447 square feet, and 117-1183, that is 285 square feet. That means about 1 decimal of plot of land that was constructed by a concrete road long ago. And that was your, for this reason, the petitioner is now actual position is out of 3 decimals, 2 decimals. There is no any excess land. And in the respect of the 3 decimal, the waiting room constructed, that is the admitted position, plot number 117,341 square feet. That means that is 174 square feet. That is the excess area. They have only I am submitting is this, my lord, at this juncture. The authority, the state government is empowered to construct a public purpose, any construction.
But not on others' property.
No,
Not
no,
on
no.
others' property unless they require or acquire the property.
Without acquiring under the Panchayat Act, he has empowered. Without after acquiring, he has allowed to construct.
Definitely. Then they have to pay compensation.
Pay compensation.
Here
For
they
this
did not acquire. There is no case of acquisition.
acquisition, he had not acquired the
They
land.
rely only on the gift deed which gave only 167.
167 for my lord. Their deed, my lord, straightway come to
Yes.
page. They have annexed their deed, page 119. They have disclosed their affidavit in oppositions. Page 119.
Yes.
That is the schedule portion, that is 121. That is RSOLR, plot number 117. দাগের জল 3 ডিসমিলের মধ্যে 0556 অংশে মোট 0167,1000, that is 167 square feet only. That is the plot number 117 only. Only 117, that is out of 3 decimals, gifted 167 square feet. Well, let's straightway come to page 138. That is that they have disclosed the entire land schedule of the 117. That is Obani Mondal, Vishnupada Mondal, one of the petitioner, Shaktipada Manna, that is also one of the petitioner. Petitioner is area is 2 decimals, and other, that is the 117, that is the Mananiya Rajyapal Sacha, that is 556. The point is this, my lord, the state authority, the Panchayat authority, without any acquisitions, beyond gifted land, that was fully demarcated by their own VLRO, how they will be, without any acquisition, they will be constructed. Only
So
paying
what is the relief sought?
relief short, my lord, acquiring, then they will be allowed to.
We cannot direct the state to acquire. We can direct it
Otherwise, he will be not entitled. A co-sharer is not entitled to encroach any land. They will be the state
Thus,
authority.
we cannot
That is not a
direct.
first.
We cannot direct the state to acquire a property. That's a discretion of the state. We can at best direct.
Otherwise,
Let us complete one sentence. Let us complete a sentence. We cannot direct the state to acquire any property. The court has no power to direct. We can at best direct them to remove the encroachment on your portion.
Yes,
The
encroachment.
question is whether that can be done in a suit or in a writ petition, and your contention on that is, since it's an admitted position, therefore the writ court can do it.
And in several occasions, my lord, it could pass this order.
What is
And my lord, individual co-sharer,
Yes.
even if apart from the state authority, individual co-sharer has no right to encroach any other's property.
No, they are not individual co-sharer.
No, I am
As a
saying-
co-sharer also,
As a co-sharer also, that principle will be laid down, my lord. For this
no,
reason,
if only in their capacity as co-sharer, writ court cannot direct.
yes,
Their
my lord.
capacity as
It-
state
No, I am saying that co-sharer has no right.
cannot. How
Yes,
can?
in every respect. Here is the
And
here
here
is
the
the
yes,
Panchayat authority. Panchayat authority is empowered under the Panchayat Act. That is, I am showing my
So
lord.
not only, Mr. Das, it's not a question of the co-sharer taking over more property.
Yes.
Admittedly, they
Property
purchased
was gifted.
only gifted.
This
Yes,
portion.
they got only this portion. The entire portion of the other co-sharer in 117.
Yes.
So they cannot encroach beyond that.
beyond that. That is my whole subject.
What is the prayer in your writ petition? Have you annexed anything? The
Yes,
prayer
yes, yes, yes.
quoted
Yes,
in-
I have annexed the writ petition.
You have annexed.
Yes.
Let us see which page, the prayer portion of the writ petition. Land Reform Act.
The, I think it is page
Yes, yes. 61, 61. Page 61.
They have already constructed.
My lord, commending the respondent not to construct any pakka building for
They have
OMC
already constructed.
or already in the during pendence of this writ application.
Oh,
During pendence of the disposition,
But you have-
construction
you
is
have
going
not-
on.
you have
I
not-
then and then filed this writ
you
application.
have not prayed for demolition or something.
Yes,
like-
yes, yes.
Where is that? Or removal of the
That
encroachment?
is an injunction restraining the respondent from interfering with the position of the petitioner in respect of the plot of land.
That's an
described in paragraph-
injunction in
And
prohibitory terms.
restraining the respondent from constructing any pakka building in the plot of land of the petition as described in the 2 of the petition
That
disposal.
is injunction
the-
restraining them from.
On that moment, my lord, they have started constructions.
Very good.
They have not completed.
So let us let us hear your learned friend. Yes.
My lord, showing my lord, only one provision, that is 131 of the Panchayat Act.
পঞ্চায়েত একটা লাগছে।
মানে দেখছি আরেকটা
একটা
বই।
কথা কিছু লাগে।
আচ্ছা আচ্ছা my lord, kindly see for a moment. 131 for a moment.
ওনাকে দিন।
The Panchayat authority is empowered.
পাওয়া যাচ্ছে না?
Panchayat Act 131.
This is acquisition.
Empower, but that means Panchayat authority, if he desires.
It is nobody's case that they have acquired.
My lord, they have.
So thus
they
we cannot
have not
direct
acquired.
the state to acquire a particular property.
No,
That's
they have
executive
not-
action.
Yes, they have not acquired till date.
No, no, it's nobody's case that they have acquired.
Yes, but my case is, my case, he has not taking any steps for acquisition. Without taking any steps for
You have
acquisition.
understood. How many times will you repeat?
Yes, yes. My whole case is, it is a plot is 3 decibels. In some area is excess. That is the constructions of the public road, their own sketch map, they are
You
showing.
can at best seek a demolition of that 174 which was encroached on your
Yes.
property. So take your seat. We'll just hear Mr. Dutt. Yes.
Lordship, my lord, your lordship has seen the prayers. Now, my lord,
There we
Yes.
can mold, Mr. Dutt. During pendency of the writ petition, if it was constructed. I mean,
Well,
why should they be relegated to the civil court?
now, my lord, it is, I think, my lord, the factual is not correct. My lord, here, my lord, I have formulated some points for your lordship's consideration. Now, my lord, the petitioner purchased a portion of plot 117. A portion of the same plot was gifted to the government of West Bengal. So, my lord, both the petitioners and the state over the plot number 117 is at par. They are on the same footing. They have come by purchasing a portion of plot number 117, and the government has come by virtue of a deed of gift executed in its favor. So the petitioners and also are co-sharers.
So therefore, since there was no demarcation by partition and
No
by
partition is there.
The petitioners have not been able to identify their own plot of land. Let my learned friends show to your lordship that which part, this is undivided, this is not partitioned plots.
So then you say that it's a case of a co-sharer constructing over a joint property.
Yes,
You might have exceeded your share, but that cannot be the subject matter. We cannot direct removal because he does not have exclusive right
Yes.
over any part of the property.
and my lord, the one vital thing is that he says that my, without compensation, without acquiring, giving away my plots of, which plot of land? Let him identify his portion of the land. He doesn't know. Because I am also a co-sharer of that particular plot of land.
But admittedly, admittedly means as per your report, you have constructed over more than this one.
Yes, I'll dispel this. Lordship, kindly have a look to page 108 of the opposition that was filed. This is very vital, my lord. Lordship, kindly have a look to page.
Is it annexed to this state petition?
Yes,
Yes,
yes.
yes.
It is 108.
Yes. Opposition.
Page 108. Page, my lordship, 108. Lordship gives a minute. No?
Yes, yes.
Lord, the lordship kindly comes to the opposition. The relevant page is page 109, 10. Relevant portions I will place. This is from my affidavit.
Yes.
1010, the second paragraph. It is true that the passenger shed waiting room has been constructed over 260 square link, not 266 square feet. It is square link of suit plot 99 square link excess, admittedly, than the recorded area in favor of the state authority. The contention of the petition is such that occupation of excess land by the state authority has resulted in insufficient ingress of the petitioners, and hence they asked for 55 square link area marked in white color in the sketch map. They demand this should go to them. Why? There are many co-sharers. Now, this lordship kindly sees. Next, in this regard, this is to state that it is an accepted proposition that the recorded area and actual field area of any plot may vary to a certain extent due to approximation and ratio of representation in map. Here, the total area of suit plot number 117 at the Khatiyans, though recorded as 0.03 acre, that is 3000 square link, but in actual field measurement, lordship marks the plot is nearly 0.04 acre, that is 4182 square link. This excess area was possessed by the original owners of the plot. From the original owners, the petitioners as well as the government, both have come. Now, the writ petitioners purchased part of the suit plot measuring 2.3 decimals equivalent to 2300 square link by virtue of 3 different registered deeds from different owners. In the sketch map, their joint possession has been marked in yellow and orange color. The yellow part is 1900 square link lying vacant, and 405 square link, that is 0.4 decimal, is within the concrete road on the eastern side of the plot and marked in orange color. Thus, they are still in possession of 2.3 decimal, that is 1.9 swans of the suit plot as per their deeds. They are still, the purchased area of my landsman's clients is still there. They are
taking into account the actual occupation.
Yes. Now the construction has been made on the excess plot of land. That is because of this the recorded area and actual area differentiation that has resulted in the excess area. Excess area, he is claiming right over the excess area. How can he? This is the dispute, really speaking. And this cannot be adjudicated as rightly held by the learned judge. This is the crux of the matter. Now he takes claim, and then I just place some more lines. Thus, they are still in possession of 2.3 decimals of land of the suit plot as per their deeds. This is also to mention that there is an electrical post within the 55 square link. He is claiming 50 square link area on which there is a electrical post which is marked in white color in the sketch map that has been shown to lordship. Lordship, kindly next page, on the other hand, one original Ananta Mondal transferred his share, this is undisputed, to the state authority for larger public interest for construction of passenger shed, which is 167 square link as per record. But actual possession transferred was more than that, which is 266 square link. He claims right over this excess land that he cannot. This is because of the actual area and measured area, the differentiation that he should be given to, and he yesterday submitted that he is not, he is claiming, his claim is that in front, construction in front of his land, not on his land. So how can he stake his claim? I fail to understand.
But he has changed that today, and he has said that a part of his land also has been encroached.
Part of the
A part of his land has also been encroached. He has changed yesterday, Mr. Das was saying that in
Yes.
front of.
yes.
That's why we put him repeatedly the
Yes,
question that whether
and they, well,
but
I
he
have
says-
stated on oath, but no part of his land has been encroached upon by the government. This is for public purpose. The public shed has been constructed, that is on a donated land, gifted land of one of the co-sharers. So he is
both you
egress
and
and
he, both you and them are in occupation of excess land then transferred to you, because the actual area measurement of that plot shows that there is excess land.
so it needs to be partitioned. This is
That
not
is the second
demarcated.
point. That is the second. Even apart from
Not demarcated.
not demarcated, that is the first point.
Yes.
The other point is that even if suppose they say that you have exceeded your area, your your share, you say that there also there is some difficulty because both of you have been enjoying excess land than that which has been transferred, because the actual measurement is more. You have added that up.
Yes.
At page 110, you have added that 1.9 plus 0.4.
Yes. That is, yes.
So actual area there now in their occupation, it comes within their share. That 3 decimal.
That is disputed because there is already a electrical post.
No, you have stated they are still in possession of 2.3 decimal,
Yes.
which was purchased.
Yes, their purchased area has still,
That
they
is
are in
what you
possession.
were saying, that you say that they are already in occupation of their purchase area,
No,
even
but-
after your construction.
No,
Plus there is this electrical post and all.
Then, Lordship, kindly allow me to place some more paragraphs at page 111.
Yes.
This, I was reading the first paragraph. On the other hand, one original owner, Ananta Mondal, transferred his share of plot to the state authority for a larger public interest for construction of passenger shed, which is 167 square link as per record, but actual possession of transport was more than that, which is 266 square link. As such, the state authority constructed passenger shed on the area which was in possession of erstwhile Rayat Ananta Mondal. The possession of Ananta Mondal was more than his actual area. That has gone to the state authority. The state authority deliberately has not done it. Ananta Mondal area has been constructed. There on that area has been a passenger shed has been constructed. Similarly, it has come from Ananta Mondal, who gifted the plot of land. He gifted the plot of land, but in the actual measurement, it shows that it is more than that he possessed.
They purchased from Ananta Mondal also.
No, some other co-shares. Some other co-shares. Ananta Mondal only gifted this land in favor of the government. Now, my Lordship, hence it appears that no land pertaining to plot number 117 of the prisoners got lost by construction of passenger shed waiting room. This is hence it appears that no land pertaining to plot number 117 of the petitioners got lost by construction of passenger shed waiting room. Petitioners' land is still under their joint possession. Further, no state respondents owned the 55 square link of plot marked in white color in the sketch map, and thereby no question arises to transfer the same in favor of the petitioners. They want transfer. They want transfer of this 55 square link in their favor. How the government can do it? The actual area donated, but on measurement, it was found that it is more than the actual area. On that area, only a portion of the construction has been made on that area. He claims that he's right. This is one of the frivolous litigation, I must tell you, Lordship. And if he has any right over that has not been partitioned, not demarcated, nothing of the kind. So this is, the writ court possibly cannot delve into the domain of a civil court, competent civil court.
And that has been done by the learned single.
That's it. So I don't find any infirmity in the order and appeal.
My lord, may I submit one thing?
Let me finish, then we'll hear. Yes, sir.
Lordship, I just, this is precisely the point, and the one, two things, I thought I should, this, no, I think, these are all,
Yes.
just nothing more, nothing more.
Thank you.
So,
So,
sorry, so,
yes, you purchase how
Yes,
much,
yes.
Mr. Das?
2 decibels of Malik straightway come to
let him
154.
identify his,
Yes,
area of-
yes, yes, I'm coming. 154 for a moment, page number 154.
Yes.
Their own sketch map, they have specifically demarcated the concrete road. The eastern side, that is the excess portion of the land of the 117. That is the concrete road already constructed long before. That means at this moment, only 3 decibels of land, plot number 117. I am owner, only 2 decibels of land. He is owner, only 167 square decibels of land. But he had constructed 341 square. There is no question of excess land I am enjoining or any other co-sharer is enjoying. Entire excess area construction was made by the public road, that is concrete road, long before. At this juncture, their own sketch map. Admitted position 3 decibels of land. Out of 3 decibels, I am 2 decibels of land. And he is the owner only 167 of decibels of land. But he had constructed 341 decibels, that is excess 174 without any acquisition. I am not, that means co-sharer property already encroached. Any co-sharer property already encroached. That is the admitted position. So without any acquisition, Panchayat authority has no power to construct under the section.
Third learned counsel for the parties. Full stop. The present challenge has been preferred against an order dated April 25, 2024, passed in WPA 5404 of 2018, whereby the dispute raised by the petitioners regarding alleged encroachment of their share of the disputed plot, that is plot number 117, was relegated to the civil court. Full stop. Next para, learned counsel for the petitioners argues that the petitioners purchased 2 decimals of land out of 3 decimals in total in plot number 117. Full stop. The said plot is the focal point of the dispute. Full stop. Although the petitioners had also purchased some property in plot number 117 by 1183, the same has not fallen for consideration in the present LIS. So next para. According to learned counsel for the petitioners, the sketch map furnished by the BL and LRO himself, as annexed at page 154 of the stay application filed in connection with the present appeal, which was a part of the affidavit in opposition filed by the state in the writ petition, it is clearly seen that despite only 167 square feet having been gifted by one of the original co-owners of the property, namely Ananta Mondol, to the state within bracket through the concerned Panchayat Somiti, bracket closed, construction of a pakka nature has been made, of a permanent nature has been made over 341 square feet. Full stop. Next para. Thus, the said construction is evidently in excess of the shares gifted to the state authorities. Full stop. It is contended by the petitioners that by logical deduction, comma, the excess encroachment in plot number 117 has been made on the shares of the other co-sharers. Full stop. Next para, learned counsel argues that without a proper procedure for acquisition having been undertaken, comma, it was beyond the authority of the state to encroach upon the portion of the co-sharers of plot number 117. Full stop. Next para, in the writ petition, comma, a relief was sought to the extent that the state is not empowered to encroach upon excess land without proper acquisition proceedings, as well as for injunction restraining the state from making construction in excess of their donated portion of the property. Full stop. Next para, learned counsel for the petitioner submits that, comma, however, comma, during pendency of the writ petition, the construction was completed. Full stop. As such, comma, it is argued that the state may be directed either to acquire the property, acquire the excess property and pay appropriate compensation to the petitioners stroke co-owners, or to remove the excess encroachment over the said property. Full stop. Next para, learned AGP, comma, appearing on behalf of the state, comma, places reliance on the affidavit in opposition filed by the state in connection with the writ petition and submits that upon physical verification, comma, as apparent from the sketch map relied on by the petitioners themselves, comma, the actual area of the relevant plot, that is plot number 117, was 4182, comma, although it was depicted
4086, their own sketch map. One page,
we'll
one.
deal with it. 4182 square link, comma, which comes to about 4086 square, sorry, which comes to about the 4182 square link, although the area has been depicted in the records of rights as well as the concerned deeds as 0.03 acre. Full stop. Next para, learned AGP further argues that as such, comma, all co-sharers, comma, including the state authorities, comma, have all along been in possession of land in excess of their deeds, comma, since the actual possession which was handed over to the state by Ananta Mondal, comma, the donor, comma, was in excess of the property indicated in the gift deed, comma, which was originally in possession of the said donor. Full stop. Next para, in any event, comma, it is argued that if the excess occupied area of all parties are, all the co-sharers are taken, comma, the petitioners are still in possession of 2.3 decimal of land in plot number 117, comma, which is commensurate with the portion stroke share purchased by the petitioners. Full stop. Next para. Secondly, comma, it is argued that the entire plot is jointly owned by the petitioners, comma, other co-sharers and the state authorities, and the state authorities, comma, by dint of their gift deed, comma, have become co-sharers of the property. Full stop. In the absence of any specific demarcation or partition by metes and bounds, comma, it is argued that no particular co-sharer can claim exclusive title or possession over a particular portion of the property. Full stop. Thus, comma, the allegation that the petitioner's portion of the property has been encroached by the state is a misnomer. Full stop. Next para. Upon hearing learned counsel for the parties, we find that it is evident from the sketch map that although the records of rights indicate that plot number 117 is of 3 decimal area, the actual area as found from the Mousa map was 4086 square link. Full stop. Next para, the constructed area, that is the waiting room, has been shown to be 450 square links on plot number 117 and 109 square link on the adjoining road. Full stop. Next para. Thus, it is clear that the actual position, that if the actual position of the properties and their predecessors in interest is taken into account, the petitioners are still in occupation of their share of the property of the plot, which was transferred in their name. Full stop. Next para. Secondly, the question of the particular position, the particular portion of the property exclusively belonging to the petitioners being encroached by the state does not arise, for the simple reason that in the absence of any proper partition by metes and bounds, either by a partition decree or by a registered deed of partition, all parties, including the state authorities as well as the petitioners, remain co-sharers of the property. Full stop. Thus, by legal fiction, every co-sharer has right, title and interest over every inch of the property, and the possession of one is on behalf of the other co-sharers as well. Full stop. Next para. Hence, the very premise of the writ petition, to the effect that the specific and exclusive portion of plot number 117 belonging to the petitioners have been encroached cannot be decided outright without taking evidence and going into the facts of the case upon documentary as well as oral deposition being adduced. Full stop. Next para. Moreover, insofar as the actual area of the plots are concerned, there is palpable discrepancy between the Mousa map and the deeds and RS records on the other hand. Full stop. Next para. Unless such a discrepancy is resolved, it cannot be ascertained as to whether the petitioners are still in physical possession of the extent of plot number 117 which was sold to them. Full stop. Next para. These issues, being mixed questions of facts and law, which are to be resolved by an appropriate civil suit, upon evidence, upon trial on evidence, cannot be decided by the writ court, being complex questions of fact. Full stop. Next para. By virtue of the impugned order, the learned single judge, upon discussing all facets of the matter and the counter arguments of parties, observed that there would be no justification to entertain the present disputes between the co-sharers of plot number 117 in the writ jurisdiction, and that the petitioners may approach the civil court for desired relief. Full stop. Next para. We are ad idem with the said observation and conclusion of the learned single judge in view of the discussions as made above. Full stop. Next para. Moreover, in an intra-court appeal, the court has to be cautious as to there being no interference unless there is a gross illegality or material perversity tainting, T-I-N-T-I-N-G, the impugned order. Full stop. We find that on a preponderance of probability, one of the plausible views on the available facts was taken by the learned single judge, Full stop. As such, comma, there is no scope of interference in an intra-court appeal on such count as well. Full stop. Accordingly, FMA 1229 of 2025 is dismissed on contest without any order as to cost. Full stop. Can 1 of 2025 is accordingly disposed of as well. Full stop. It is made clear that the merits of the rival contentions of the parties have not been gone into by this court, and it will be open to the parties to resolve their disputes by filing a proper civil suit before the competent civil court. Full stop. Urgent certificate copies.
No, only I am submitting, my lord, their own case, my only this is the pointed out, the concrete road is there measuring such and such area. That is their own measurement report. That is the excess.
Road, you have no right over the road.
Lordship,
That is-
Next.
Deeply.
My application for contempt, but the Lordship recalls this is a defense, suit filed before the district court, but refusal of auditory order of injunction. We had preferred an appeal. Lordship had granted an injunction on 16 June 2025, restraining the defendant or the respondent from making any defamatory statement to me or as well as to any third parties. When some patented technology he was claiming right on.
There is some defect. Oh, that was in the appeal.
That was in the appeal, yes.
Right. Then?
But then, we had communicated the order to him, and there was also a response. I do not want to place the words which are there in the response. Kindly comes to page 185. Or may I show you, Lordship?
That response is the contempt, or
that response is
185.
185. But 185, Lordship sees the email at the bottom.
Yes.
22nd June 2025 is an email from the defendant. Dear sir, I'll not place it, but the first two lines are that I have misspelled the name of his village, and that amounts to an insult to him.
Where is the misspelling? Let us, we are very
But,
curious now.
But he's saying the name of my village, which is known as the
That we have seen. Where is he says that you insulted them as such and such.
Yes, insulted as such. I don't want to say that one.
So,
name is
what is the
Kadir.
context of using that expression?
I don't know. Maybe in the
Kadirur means something.
Means something. Maybe in his vernacular language. I'm not aware.
What is his vernacular?
He's from Kerala.
Achha.
But
this much.
But then yes, and then kindly comes
the right to use slang falls within the connotation of right to live.
Absolutely. That's not that
right to live a proper life of dignity.
Yeah, it feels
you can use slang if you want to live a life of dignity.
Yes, it feels better as well sometimes.
So the expression is very interesting, but
well, not this. When it kindly comes to page 186.
186, yes.
Here, Malad, he says, but this is an act of contempt because he says that I'm a fraud and I've cheated. But after getting the patented technology and the working model, don't you have any shame in cheating a poor man and not paying his dues and then trapping him in a case, making him suffer for years? You're a scoundrel who has been pursuing a case.
Just show us our order. Which page?
Actually, we'll kindly take the first order at page 175.
The order by which we actually injuncted him.
Yes, 175 is the first order. Kindly sees page 176, paragraph 7. This is the first order Lordship had passed on 16 June.
That writ petition is still pending.
The suit is still pending. But this is coming up by way of an appeal.
No, the appeal is still pending.
Appeal is still pending.
Not writ petition. Sorry.
The 176, paragraph 7. The defendant such and such shall remain restrained by an order of injunction in terms of press in Can 1 to the effect that defendant shall not by himself or through his man agents such and such circulate any article or issue any statement to the appellant and or to any third party either through email, media such and such containing words similar to the ones used in the letters and communications annexed as Annexure G to the plaint, as well as any other communication having
this was designed to injure the business and goodwill. This was on a personal level.
But in Annexure
this
G,
is slander. You may file a defamation,
but Lordship has restrained him from making any communication insofar as whatever he has stated annexed as Annexure G to the plaint.
Achha, let us see that what he originally stated because it is tied up to that.
But annexure G to the plaint, annexure G to the plaint, what you will find at page 97, which is summarized at page 59 of my plaint. 97, there are various documents.
97 of this application.
97 of this application. Annexure G, Lordship has seen, it starts from page 97. There are multiple communications. Now, I have summarized one of this.
But this does not hit your business or goodwill. Let us see again. After getting patent and working to have cheating a
He's also calling me a fraud at page 98.
Please, but these 98
Or
fraud is-
198, I'm sorry. 191, I'm sorry. 191. I'm so sorry.
No, but these are at a personal level. But our
at a
contention
personal-
was to damage your goodwill or something like that. Because he had been alleging something.
He had been alleging that he has a patent and I'm
And you are
using his
violating-
patent. Yes.
Yes, you are violating that.
Yes.
So this was intended to protect that, right? So that he cannot violate your goodwill or your
Or the reputation.
reputation of the
also-
company.
Yes, reputation of the company. Lordship had restrained him from making any false communication to me insofar as they are summarized in Annexure G to the plaint.
But there were no allegations of this sort in the previous ones.
In
to
the
which we
previous
tried-
ones, in the Annexure G to the plaint, which I have summarized in the plaint by pleadings, he had said that I am a fraud. He has also been communicating to my own customers, retailers, saying that don't buy things from me because these are in violation of his patent. Now that was the cause of action, and thereafter, my lord, we had made prayers at the main relief sought in the suit was that restrain him from making such communications, calling me a fraud or calling me a company which is cheating him.
Will issue note, will issue direct
Praying for a rule to be
subcopies. By an order dated, this order was extended subsequently.
Yes, my lord. This order was extended. My lord, Lordship will have the order at page
no.
187.
This is the main order.
Right.
By an order dated June 16, 2025.
My lord, may I interrupt only once? I'm so sorry. I forgot to point this out. Page 191, if your Lordship has once again. This is a communication not only to me, to BBC channel as well. 191.
Because a psychologist.
191, my lord, the bottom email, 13 July, Lordship will see 2 Excite Care, such and such, and BBC News Channel, BBC UK. Everyone. My lord. This per se, my lord, amounts to violation of the order.
By an order dated June 16, 2025, এই অর্ডারটা তুমি নিয়েছিলে June 16, 2025, passed in Can 1 of 2025 in connection with FMET 190 of 2025, comma, this court had restrained the alleged contemner from, comma, by him, from threatening, comma, publishing or circulating any article or issue any statement to the appellant and or to any third party, comma, either through emails, comma, social media or through any other media whatsoever, comma, containing words similar to the ones used in the letters and communications annexed as Annexure G to the plaint filed in title suit number 639 of 2025, as well as any other communication having the purport or effect as mentioned above, therein above, or designed to injure the business and goodwill of the appellant and or any other threatening communication in any other manner whatsoever having the effect of defaming and interfering with the business and regular affairs of the appellant company. Full stop. In Annexure G, comma, certain abusive words were also used against the petitioner company. Full stop. Subsequent to communication of the order of this court, comma, however, comma, the alleged contemner has, comma, apparently, comma, as per the annexures to the present contempt application, comma, repeated the abusive language in communications not only to the petitioner but also to several other entities, comma, including news channels. Full stop. Next para. Inter alia, comma, apart from using derogatory and abusive language, comma, it has been alleged that the petitioner is cheating the alleged contemner. Full stop, next para. On a bare perusal of the said emails, comma, a prima facie, we find that a prima facie case of contempt of the order of this court dated June 16, 2025, comma, as extended subsequently, comma, has been made out in the present application. Full stop. Accordingly, the appellant, the petitioner shall serve a copy of the contempt application along with its annexures to the alleged contender, indicating that the matter shall next be listed for hearing on September 11, 2025, when an affidavit of service shall be filed by the petitioner. Full stop. Affidavit in opposition, if any, shall be filed by the alleged contender by August 28, 2025. Full stop. Reply, if any, shall be filed by the returnable date.
Grateful. Thank you.
We are not issuing rule right now. Let him come up.
Good. Grateful.
এবার 6 থেকে 21 বোর্ডে একসঙ্গে শো করে। হ্যাঁ, তাড়াতাড়ি তাড়াতাড়ি 6 থেকে 21। এইগুলো সবকটা আলাদা আলাদা অর্ডার হবে, কিন্তু সেম অর্ডার, যে অর্ডারটা বলছি সেটাই।
Six, I am the respondent.
Yes. Since this court no longer, this bench no longer has determination to take up hearing under Order 41, Rule 11 of the Code of Civil Procedure, comma, let the matter stand released from our list with liberty to the learned counsel for the parties to mention for enlistment before the appropriate bench having determination. This much. 6 to 21, separate orders, same order.
Item number 22.
পাস ওভার, এগুলো প্রথমটা কেউ থাকবে না, কেউ অ্যান্টিসিপেট করবে। পাসওয়ার্ড, পাস ওভার। আচ্ছা, ওই ইয়ে শুধু অ্যাসাইনমেন্টের শুধু মঙ্গলবার নেবো, ওটা তো সরে গেছে। আচ্ছা, 24 to 26 পাস ওভার। এত পাস হয়েছে, দাঁড়াও 1 মিনিট দাঁড়াও, আমরা ব্রেকটা এখন নিচ্ছি, নিয়ে ঘুরে আসছি, ওদের দেখুন 10 মিনিটে চলে আসবে। বোর্ডে লাস্টে যেটা হয়েছে সেটাই শো কর। আচ্ছা, পাস ওভার গুলো ডাকো একবার, 22টা শো করবে। হ্যাঁ, এটাও পাস ওভার, আবার পাস ওভার যেখান থেকে হয়েছে।
My lord, 22, I'm there, my lord. Mr. Anindya Mitra is there, my lord. They
We
are
are
all
doing
come.
this. We are doing this. We understand that you have been taken by surprise because so many matters. We will take that break which we take now, and we'll come back in 10 minutes. If you please take the trouble of informing
I'll inform her.
the others also. I mean, if you can.
I just rushed out to
No, we
inform.
understood. We understood. That's why we are going slow and passing over and doing this thing. So we'll take that break now so that you can come back with your counsel. 20, 20, 22, yes.
I'm for the appellant.
Before my
No
lord,
opposition has been filed. That is the office report.
I am for the respondent number 9, my lord.
No opposition has been filed by anybody. Do you give a copy to them?
I have given earlier.
As you are ready with the
My
reply?
lord, before the submission start, may I just indicate one thing, lordship? The respondent number 9 is 76 years old. The authorized representative who has affirmed for the appellant company is constantly calling my client and threatening him to withdraw. He's threatening him not to sign any documents, not to prefer any litigation, and to also not take any steps in the instant matter. I have taken out a formal affidavit, lordship. May I file it in court just to bring this on record,
But you
lordship?
have to give them copies also.
I have copies, my lord. I'll serve immediately.
Milord, so far as Mr. Mitra, my learned senior advisor is concerned, Milord, let him complete today, Milord. Give me a chance, Milord, to address your lordship, Milord, Tuesday, Milord, subject to convenience.
Yes.
Tuesday.
Mr. Mitra, please ask your learned junior, whoever is contacting with the client, to just take information whether this is true or not.
Well, this matter I do not know. What is this?
So this, how can you know? None of you know, but that your client is threatening her client.
My client is threatening.
Yes, my
So
lord.
it should not threaten.
My client is
File an
pleading
affidavit.
phone calls,
Doctor, can
lordship.
it's an injunction restraining threatening. Nobody to threaten.
No, but it still take instruction if.
But I'm sure that this is a respectable company. It can threat করবে কেন? Don't threat. That I don't approve of this.
Anyway, একটা line record করো. An affidavit is filed today on behalf of respondent number 9 alleging that certain threats are being issued on behalf of the petitioner company to the respondent number 9, which is denied by learned senior counsel appearing for the appellant for the petitioner. Full stop, next para. The affidavit may be kept on record. Full stop, however, comma, since the application itself is ready for hearing, comma, we take up the application for hearing.
You oral
Full stop,
threats
next
not
para.
written.
Affidavits in opposition and
Oral
reply
threats.
filed today be kept on record.
Oral threats.
So, Mr. Mitra, let us start the hearing.
No, let's get that. It's an appeal has been was filed before the tribunal from the order of Thikatinsi controller. Thikatinsi controller held that the appellant is a firm, a partnership firm of two partners. That is appellant number 1. One of the two partners made himself also appellant number 2, Odun Chandra. She is a constantly also made him appellant number 2. Not totally at all.
There is only one, the petitioner is only
the
the company. No, this is
Yes, appeal kota. Appeal memorandum appeal ta dauna khali to hobe. Memorandum of appeal ta kota. Huh?
What is the memorandum?
Okay. Next দিয়ে দাও, page number দাও।
পাওয়া যাচ্ছে না land reforms.
Volume 2. Can you take volume 2?
373.
376. কোথায়? আমি তোকে মেমোরিয়াম অ্যাপিল যেটা ফাইল করেছে ওরা অ্যাপেলেন্টটা কারা দেখা বলছে ভলিউম 1 পেজ 135 ওটা দেখো That is the memorandum appeal. Volume 1. কোথায় পেজ নম্বর লিখে রাখতে হবে কি দেখো তো বলতে ফুল কস্ট কোথায় one page 66 page 66 below kindly come to volume 1 page 66.
Yes.
Cost title description of the applicants that is a appeal in the appeal. Measures Khanna and Sons, a
Yes.
partnership firm,
Yes.
etc. And that is Arun Chandra being one of the partners of Khanna and Sons.
Right.
He was unnecessary party made himself. His Arun Chandra Khanna died,
Acha.
and his representatives applied for substitution. Question was this whether right to survive. Firstly, whether Arun Chandra Khanna had a personal right to sue.
What was the application for? I mean, what was it?
Substitution of his heirs.
Now, what was the main relief sought before the tribunal?
Tribunal. Was appeal filed by them against the order of Thika controller.
Declaring that it's a ticket.
This partnership firm claimed to be Thika tenant in respect of the property
Yes.
in Calcutta. That
Right,
my
right.
client is the owner now. Now,
Thika controller held they are not Thika controller.
Thika controller held, they are not Thika controller because what was let out, not to his Khanna and Sons, but to the predecessor, a land with structure. He held that. That was land with structure held out. So he did not, secondly, they had not proved the construction of structure.
So that
And-
was challenged before the tribunal.
Tribunal.
Tribunal affirmed that.
That's pending. Appeal is
Obviously
pending.
not. Obviously not. You
Appeal
have-
is pending. Appeal is pending.
Acha, so what is the present relief
Then
sought?
in the pending application is for Arun Chandra Khanna died during the pendency of the appeal.
Hmm.
His heirs applied.
Hmm.
And let's see the application for substitution. This is page 66. Hmm? No, that's the application.
No,
5 page, very concise application. And immediately come to page 135. 137. 137. Can you come to 137? Let's see the petition. There is no averment or anything that the right to sue survived or anything.
Huh.
Yes, please say the petition. Page 140 starts after constating. Telling the improved order, tribunal. This is a very important paragraph. 3.
No, the partnership deed was produced.
Yes, it's on record.
Does
It's
it
on record.
contemplate that the heirs of the deceased partner will come in?
No. That will be the discretion of the other partner, continuing partner. Whatever deed is there on record. That is, ask me a very apt question. That is the word.
So we'll just then the application we have already read. Simplicity substitution application like a suit. I mean, died and
Right to sue survives. That is no allegation, no averment.
no, but because as you said, it's a partnership firm, which is the
Partnership firm.
So can we just have a look at the partnership deed now?
Yes, certainly. Page 120. 122. Page 122. Is a typed copy.
Yes, that
It is a other copy. It is typed copy. The relevant clause which my lord looking for most probably is clause 4 and 5 at page 125. 4. That the present partnership shall continue in the lifetime of the partners hereof unless previously determined. 5. That on the death of any of the partners during the continuance of the present partnership business, the surviving partners are entitled to continue business of the firm either by themselves or by taking legal representative. This is the paragraph. My lord, I think looking for this.
So then there is no proof that they were taken in.
No, there is no abatement, nothing said. And in fact not taken and could not be taken. They are not good terms.
It was let out to you. You are the petitioner.
That I am the purchaser of the property. I am the owner of the property.
Owner of the property.
The owner of property by purchase. And
So you have challenged that allowing of the substitution application?
yes,
No, what remains is only to see the impugned order once of the tribunal.
it's a
See the impugned
tribunal
order and
order,
then
it is to be heard, but unfortunately, tribunal has held on the simple petition substitution, he has held that vacant land was purchased,
yes.
and on that construction was made by Khanna and Sons.
But that is on the merits of the matter, in fact.
Totally, that is finding of that is stated in the judgment.
But only while hearing the substitution application.
Substitution application.
Can you please place the impugned order, Mr. Mitra?
Yes,
You will
no,
just
it's the
right away
impugned
come to the impugned order.
Volume, can you take me to page 373?
26 July order?
373, volume 2. 373. Volume 2.
Yes.
It's very matter gone into great depth. Great depth, but something.
No, but Mr. Mitra, there is another angle to it. The partnership firm is an unregistered firm.
Yes, yes, that's another point. I'm not reading it. I'm taking first point. Whether order, there could be a question of substitution at all.
But then they might have argued probably that they filed in their individual capacity, but that is not the scenario because in the application, main application itself, they have described
by the firm.
By the firm.
And the property of the firm.
And property of the firm. Yes, property of the firm.
Now, let's see what kindly be seated off the line. What do you say?
So you did not take 69, section 69 objection?
We have taken. That point was kept
Obviously,
open.
yes.
That point, when the appeal was admitted, the point was kept open specifically as a preliminary point. But he is not urging. Again, we said kindly decide the preliminary point first, and then. But yes.
Substitution has to be taken up first because if it's required, then in the name of
right. Okay. Well, what is done? The damaging thing is, can you see that at page 374? Third paragraph. Premchandra Khanna, in deceased, being a petition the proposed applicant, he was a partner, sought to be substituted, was inducted as a tenant on a bare land with certain monthly rent. That is exactly contrary to Tika contra held. Next paragraph. After constitution of partnership firm admitted and registered with alleged consent of the landlord, a temporary structure was raised on the bare land. Nothing remains on my matter.
That is their case, maybe. Is he discussing their case?
Yes, held the ticket in the right goal. The opposite, just of reversing the order of ratio of the order of Tika controller. So,
Admittedly comprised of 4 partners out of 4. No, he's not discussing their case. It's his own observation.
I'm saying that this is that's the now see the ground on which he is acting. On what ground he is allowed? I can summarize and tell you, Lordship, but not read the judgment. I won't disturb your Lordship while reading the judgment. That Premchand Khanna was inducted as tenant of bare land and he made the structure. He said, as the partnership can legally continue business activities only for winding up contributors.
You're reading page?
I'm summarizing what is ratio. Now, not read it, but it's long, very long judgment.
The arguments continue.
I should read it. I leave it to you. Lord should read peacefully, uninterrupted by me, or
no,
whatever my lord
no
way of.
question of interruption, but just check up.
Okay. That's what the 135 got to page, 137. He has not decided the main
No,
thing.
sir, what is the
whether
reference to some civil suit? He refers to some civil suit.
Civil, it is a Tikatini controller proceeding start by an application.
No, he refers to title suit number such and such. There
That
was a
is,
title suit by somebody.
it's a title to Naliput court. What title is,
That was a title suit filed by the partnership firm.
yes, yes.
Against whom? You.
Against case.
My predecessor.
My previous my
Predecessor.
predecessor.
And that was a suit for what was the reliefs claim there?
Declaration of,
So there they were substituted apparently.
no, that.
So how is that referred to? In what
I
context?
don't know, that totally not relevant anyway.
It was argued on your behalf.
Oh, that suit was filed by a firm.
Then relegated to the
The
ticket.
suit was dismissed. Dismissed for default.
Acha.
No, not on marriage. On marriage. Suit was dismissed.
Ah.
That is the stage.
Or as not maintainably relegating him to the ticket controller. We don't.
On marriage, I think. Well, I have not gone to the. Oh, I see. No. So, ex parte degree, order 9, rule 13, that was set aside on our application. And then. Restored.
You can give the instructions a bit loudly. No, give the instructions a bit loudly so that we can catch up.
Suit was decreed ex parte, order 9 rule 13 for filed. It was allowed. Suit was restored. Thereafter, the suit abated because due to death of the parties, abatement was challenged. That was also rejected. And now an appeal challenging the setting aside of abatement is pending before.
So are they citing that to show that it had abated? So here also it should abate.
No. Yeah, but that I don't find relevance. That is a proceeding pending. Pending that this Tikatini proceeding was started by the both parallel proceedings started. The Tikatini controller, same.
They probably want to draw analogy from that suit, saying that if that could have abated, then this will also abate.
Yes.
And this order 22.
That one I am not taking. This one was not taken because that should abated. Because I'm saying that this suit has two parties, all the parties have not died. My point is different in this case.
No, that was a suit for dissolution.
No. Declaration that Tikatini, that suit wouldn't lie.
That suit.
That suit is barred by the Tikatini Act. Because only Tikatini controller can decide.
No,
Anyway,
the 69(3)(a) exception has been some protection to unlisted for any right to realize property. That is pertaining to dissolution, after dissolution. Here there is, it is not their case that the firm has been dissolved.
No, not their case.
And in the substitution, they don't say so.
No.
Because still their claim is on, the partnership is the petitioner number 1 before the tribunal. Rather the appellant number 1 before the tribunal.
Yes. So, as the partnership firm claiming to hold a Tikatini right on my land. Right? And the partnership firm is the applicant before Tikatini controller. And that is the appellant before the land tribunal. The firm is there on record. Firm has been dissolved. That's another point also find. That firm has to dissolve because there are two partners only. On the death of one partner, is to dissolve.
No, the finding of the tribunal is Mr. Mitro at page 381, page 9.
381.
That admittedly, out of the 4 partners, 3 partners have already left this one.
Already left.
So only this Arun Chandra Khanna was there. How could it remain as a partnership?
The partnership is to dissolve by operation of law, section 42 of Partnership Act.
Yes.
What is to?
Well, another partner is still living.
Sole partner is there.
Apart from Arun Khanna, somebody else is still living.
I am respondent number 9.
You are that partner whom they are threatening to.
Yes, my lord.
Don't accede to their threats. Carry on.
Only one person survives. Therefore, firm has dissolved.
But the tribunal, what is their name? Respondent number 9's name?
Tarun Chandra Khanna.
Torun Khanna.
Torun Khanna. Yes.
But it's recorded in the impugner itself that admittedly out of 4 partners, 3 have already left this one. Anyway, Torun Khanna.
My client already. My client died
Yes.
and another 2 partners died.
Torun Khanna is still there.
Torun case.
Yeah, and Torun Khanna is there. But there cannot be one partnership, one partnership. That is that's what I was saying. And it is recorded.
But
in
Torun
the-
Khanna could induct as per the partnership, it could induct the others.
No,
They
no,
have
no,
taken
no,
out an
no,
application
no.
for transposition also in that tribunal.
Now, Arun Khan is not that case that a Torun Khanna inducted Rias of Arun Khanna. No, no, that is not the case. That is not the case. And there is not a case in the petition, nor is held in the judgment. So, partnership firm of one has to dissolve.
Partnership একটা আছে?
Yes.
The tribunal relies on 69(3)(a) only.
আবল তবল বলে গেছে।
Thank you.
Doctor was seen page 374, if a tribunal notes that one partner is alive as on date.
But then why is respondent number 9 a party?
He made them a party. This
No, this is you. Acha, because they were a party in the appeal.
no. They were secretary control proceedings.
No, you have implemented them because they were parties to the.
Yes, as I've taken the costly appeal, that's all. Taken the costly appeal. 42 lost knows. Lost got
69(3)(a), I will forget the law. I mean, how is this applicable? Tribunal applies 69(3)(a).
Yes.
That relates to dissolution.
69(3)(a).
Because 69 bar won't apply to any proceeding for dissolution of a firm. This is not a proceeding for a dissolution of a firm.
No.
How is palpably bad order apparently? Let us. Yes.
I'm on the main thing. If you want to substitute as a court has first to hold that the deceased plaintiff has a right to sue, and that has survived.
Utter confusion apparently.
This is not now as finding even. And this point was argued, not to find Mr. Subrata was to appear 377.
Where?
377. This point was argued.
77 actually.
That is. And my main.
Yes.
We have considered this.
Right.
Then ratio part judgment starts at page 380. We have considered. And then we are called upon to answer the only question whether right to sue survives or extinguishes in the given circumstance of the case as written by both parties. Right to sue of Arun Khanna, two questions arises. Whether Arun Khanna had at all a right to sue personally. Has the individual personal right to sue? He did not have. He was as a partner, firm had it, as one of partners. And then upon his death, his legal representative did not become partners.
Oh no, apparently Torun Khanna is still there.
Only one.
But with death of Arun, the partnership dissolves. That is section 42.
They admit in this order also, Milord. In order, at page 374 also find the second paragraph. Can we come? This is admitted position.
Yes.
374. Second paragraph. Yeah.
Yes.
Very good.
And their case is that this is an asset of the partnership firm. That is their case.
Yes, that's like a partnership firm asset. That is the case, which was rejected by the time. That is the case. Then upon dissolution, what assets remain?
Obviously, yes.
Ticketency right under the statute, is not transferable. It's not transferable. See with the Ticketency Act clearly. And partnership assets, movables, immovables, are all become all movables. As Supreme Court held that because upon dissolution, you have to sell all the assets, collect the money, meet the liabilities.
Yes, probably the tribunal. I don't know. Section 69(3)(a) was applied on the presumption that it's a dissolution, but
no.
If it's even if it's a dissolution scenario, this is not an application for a suit for dissolution.
No.
This is something completely else.
Yeah. and he does not hold that.
This is under section 5 of the Ticket Tenancy Act. So this is not a dissolution suit.
No, no.
So how will 69(3)(a) apply? We don't know.
That was the argument made by the other side. And now, my lord, right to super dissolve from, etc. What is the finding that Arun Chandra Khanna had the right to sue, on his personal right to sue, and that devolved on his heirs?
Find anything. Yes, Mr. Basu succeeded in that forum. Yes, Mr. Basu, you succeeded there. Yes.
Yes, Milord, kindly allow me to address your lordship, Milord. I will come, Milord, only Milord, Tuesday, Milord.
Come at 2 p.m. today. Because
Today, 2 p.m. Milord. Today, 2 p.m. Milord.
We have short of matters. Mr. Basu, we cannot afford to grant you time.
Milord, only Milord,
Short
then
of matters.
tomorrow, Milord, kindly give us today, Milord. One matter is continuing before Justice Mukherjee, Milord. The employees matter, Milord.
And continue. That is being argued by somebody. Let your junior take notes
No,
there. You complete
no,
this.
Milord.
This will be over in
Milord,
5 minutes. This will be over
no.
in 5 minutes, we can assure you. 5 or 10 maximum.
No, Milord, kindly give me a 1 day time. Tomorrow, Milord, at 2 p.m.
Mr. Basu, we cannot afford that because we are short of matters.
Kindly
Clearly, we have only 2 other appeals. We don't know whether those will be done
Milord,
or whether those will finish like this.
Milord, tomorrow 2 p.m. Milord, I will address you. Give me
No.
time.
Today.
Today, Milord, kindly pardon me, Milord. Today, really, I'm in difficulty, Milord. Tomorrow at 2 p.m. Milord, I will come.
Not 2 p.m. The first thing in the morning.
Milord,
We don't have other matters, Mr. Basu. No, sorry.
Only, Milord, why I am telling your lordship, division bench comprised of Justice Boshak. I am for the High Court administration. Milord, our turn will come tomorrow, Milord.
Justice Boshak, how much time will it take? We'll take it up at say 11. By
I
then,
will take Milord there 10 minutes.
by then it will be over before Justice Boshak.
If I pray for Passover, Milord, kindly. Milord, kindly.
No, Mr. Basu, it's a competition between Justice Boshak's bench and our bench. Legal dispute. So it will be over.
Mr. Basu,
Tomorrow I will do
not
it.
short of work. Apparently, Mr. Basu is short of work. Court is short of work.
Court is short of work, right?
And Mr. Basu is not short of
Yes.
work.
Mr. Basu, sorry, we can't, we will adjourn it at best till tomorrow. We can't assure you of 2 p.m. Whenever it is taken up, if you are not ready, you have to prepare your
Tomorrow,
juniors.
Yes.
Friday too. No, tomorrow Friday.
Oh, not tomorrow. Monday morning.
Tuesday not possible, Milord. Monday I will not be here.
Where will you be?
Milord, possibly in Delhi.
Delhi?
Only
Mr.
one.
Basu, this is a very short matter. We have heard
I
it.
know, Milord, your lordship will take only
Please come
5
back at
minutes.
2 today.
Today,
You
Milord,
argued the matter in the before the
tomorrow,
trial.
Milord, I will address your lordship. Tomorrow, Milord. give me
Tomorrow
time.
we sit singly.
All right, Milord. Monday, Milord, I will address your lordship virtually.
Will argue
On a
from the
virtual
aeroplane or what?
No.
We heard learned senior counsel for the petitioner, full stop. On the period of learned counsel for the, you are for respondent number?
6 to 8. 6 to 8.
Respondent number 6 to 8. The matter is adjourned till August 11, 2025. When it will be listed under the same heading. It is same
Deeply
heading.
obliged.
Bracket পাঠার দিয়ে করে।
Deeply obliged.
At the top, molar stop. হ্যাঁ, appears পাঠা ঠিক আছে। At 2, lordship said at 2.
No, not at 2.
No.
Normal.
Deeply obliged.
If it appears as partner, it will have top position. Oh, great.
Deeply obliged.
Thank you, Mr.
Me too.
But I apologize for the inconvenience.
It could be good to know.
This matter also you apologize.
No. No.
Huh?
No.
23. Yes. Why are you looking at us like that? You must be for some of the parties.
23, Milord, I have not received the paper book from the department. The department is not.
We have filed 8 copies of paper book in the department, Milord.
You did not take it. It's your fault.
When? Milord, my clerk, when Milord, the department is not allowing us.
That maybe they did not file Milord Vokalatnama. That is the only
There is
possible.
a caveat.
Why are they not permitting? They
Milord,
have given some.
I have ascertained, Milord, they said the lower court records have not yet arrived, therefore we will not allow it.
Perhaps, Milord, there has been a change of advocate on record. Earlier, Milord, different set of advocates were appearing.
What is the matter about?
Milord, this is an appeal against an order of remand. my lord, I filed a suit, my lord, on the ground of reasonable requirement, default, and MOP of section 108 of the Transfer of Property Act. Now, my lord, the suit was dismissed. A suit was decreed. I got a decree for eviction.
On which grounds?
On the ground of, my lord, first, for non-compliance of section 7.1 and 7.2, defense for delivery of possession has been struck up. They are not entitled to any
But
protection.
automatically it does not happen.
No, there is a issue was framed and
Default. And
default. Reasonable requirement also, we have won, and my lord, we could not prove MOP. One. Number two, my lord, they have, my lord, preferred an appeal. Tenants have preferred an appeal, where only on the first point of the maintainability of the suit, my lord, the trial court has also decided the maintainability of the suit in our favor.
why not maintainable?
Maintainable, my lord, in the defense, they had taken one line observation, one stray sentence that the suit property has been vested, my lord, to the state after the promulgation of the Thika Tenancy Act. Now, my lord, that would be only on that ground, without going into other grounds in the merits of the suit, the impugned judgment was set aside, and the learned appellate court has, my lord, held that since the proceedings before the Thika controller is pending, I am remanding the suit. The trial court should wait till the proceedings of the Thika controller and then decide the suit.
So why demand it then?
My lord,
why demand? The appeal court itself
why
could have waited.
itself could have one. Number two, my lord, when, my lord, defense against delivery of possession has been struck off, I did not, my lord, take the point of Thika tenant. It is not in the four corners of the plaint. I have said that I am a Thika tenant, they are Bharatia. That they are taking the point of, my lord, Thika tenancy. Therefore, my lord, after defense of this struck out, whether their defense can at all be looked into. On that point, my lord, we have referred the judgment of Modula India versus Kamakhya Singhdeo. Court said that I can cross-examine them. Court said that the defendant can even, my lord,
Point out the fallacies.
fallacies in the
Yes,
plaint.
yes.
But my fallacy, my lord, defendant, but could not, my lord, my lord,
Say 5.3 presupposes that if any question arises as to whether a person is triggered, question can arise only if there is an issue regarding this point. So they
issue
just,
was framed.
but the defense was struck
Defense
off.
was
Therefore,
struck off.
That is a part of the defense. If that defense is not there, there will be no question because you,
And that is the only, my lord, sole point of remand. And my lord, that is the,
but
my lord,
also Mr. Bhattacharya, but another aspect is there not only 5, 8 is also there.
yes,
8 is also there.
yes.
So let us see the language.
That is also discussed by the learned trial court in details. My lord, exhibit, my lord, G, my lord, is the, my lord, TR form. TR form. The learned trial judge has specifically stated that it is only at their own risk and peril they have deposited rent with the Thika controller. But there is no conclusive and final adjudication of the rights of the parties, whether they are Thika controller or Bharatia. One. Number two, the defendant, my lord, fell in their own trap. They had, my lord, produced the, my lord, rent receipts. They used to, my lord, deposit rent to give rent to the original landlord. They fell in their own trap. Number three, the learned trial judge has specifically, my lord, scrutinized the rent receipts and the ground and the challan for deposit of ground rent. Nowhere, my lord, this premises number is given.
Eight 3 says any case of eviction of Bharatia shall be disposed of by the controller in such manner as may be prescribed.
Yes.
Now it does not say not only restricted to dispute. 3 starts with any dispute regarding payment of rent.
Yes.
8.3 any
8.3.
dispute regarding payment of rent
To the state government or by a Bharatia
or any case of eviction of Bharatia shall be disposed of by the controller. So isn't it prudent for the court to wait for it to be ascertained as to whether they're a Bharatia, it's a Thika tenancy? Even if that point was not taken, the suit, maintainability of the suit would be hit by not only section 5 but section 8.3, which does not, irrespective of independent of any dispute being raised.
Definitely, but in that case, my lord, their defense should have been there. Their defense has been struck off, and that's why, my lord, we relied upon, my lord, Modula India's case before the appellate court. To what, my lord, extent the learned court, appellate court, my lord, could have, my lord, permitted them to. My lord is absolutely right.
And we are not finding any reason for remanding either way.
The appeal court could have waited, my lord, itself.
Yes, itself. Why remand?
In the matter, what happened that the Thika controller has passed a judgment in favor us, declaring us Thika tenant. My lord, they went to the appeal, my lord, stay has been refused there.
Acha, so as of today, the position is that it's a Thika.
Now, my lord, those
I can
documents are not part
No,
of the
we
record.
understand, but what would be your answer to this? Because you cannot take any defense. That is a difficulty. If you can't take any defense, this defense is also a defense.
This is actually a point of law.
Mixed question at best. Whether it's a Thika tenancy or not is a mixed question. Not a pure question of law. Not a pure question. There has to be pleadings that it's a Thika tenancy. Or at least that it has been declared to be a Thika tenant. Civil court, if it is filed before the civil court, suppose there is no defense, we'll proceed on the basis that it's an ex parte decree. Then there is no question of this, I mean, this 3 bar coming in. 8.3 says, any dispute regarding payment of rent by a Thika or any case of eviction of Bharatiya shall be disposed of by the controller in such case.
Yes.
Very difficult if your defense is struck out.
Even in 7.2 application was filed by them when landlord-tenant relationship was, my lord, established. For non-compliance of 7.2.
No, it's a question of jurisdiction, subject matter jurisdiction of the civil court.
Then, my lord, landlord-tenant relationship was there.
Landlord-tenant relationship is provided in section 8 also.
8 also, yes.
That provision is act will govern,
That will
but
be
that will be
independent
decided.
adjudication.
Eviction decree order will be passed by the Thika
Controller.
controller, not the civil
Civil
court.
court.
When was the suit instituted?
After 2001 Act. That is also, my lord, recorded. That point was also.
Yes. You're ready in the matter.
No, not ready, my lord. Kindly,
We need not look at anything else, only to the judgment.
kindly
These
give-
are the facts. These will be evident from the judgment itself.
kindly adjourn it for a day, or at least, my lord, this week.
Give us some work for the rest of the day. Ensure that the other matter will happen throughout the day. Otherwise, we won't.
I am not yet prepared.
Come back at 2. Why shouldn't you be prepared? We are only on the judgment, which must be before you.
Kindly adjourn it for a day, my lord, next week.
Heard in part on the prayer of learned counsel for the respondent, the matter is adjourned till August 11, 2025.
And may I get a paper book?
Leave me now.
Yes, sir. Paper book এখানে extra copy আছে আমাদের দুটো ছাড়া। আচ্ছা, এটা অর্ডারে রেকর্ড করুন। A copy of the paper book be handed over to the.
All 8 copies have been sent here from the
আচ্ছা,
recorders.
it is submitted. একটা লাইনে add করে it is submitted by learned counsel for the respondents that no copy of the paper book has been served on the respondents. Full stop. Let a copy of the paper book be served on the learned advocate for the respondent by our officer here and now. Full stop. তারপরেই রেকর্ড করো. In terms of the above direction, comma, a copy is handed over to learned counsel for the respondents. Come prepared on Monday, will be. এটা পাঠার হিসেবে এটাও দেখি। ওইটা আগের ট্যাগ নম্বর পাঠার, এটা 2 নম্বর পাঠার। মানে যেরকম অর্ডারে ছিল আর কি আজকে। সেরকমই থাকবে, একই জিনিস থাকবে, শুধু ব্র্যাকেটে পাঠার।
My lord would be free, my lord, for the next half.
Yes, we have one matter reserved from Jalpaiguri death reference, so it will take some time. We'll do that today. Yes.
Grateful.
This
Yes.
is the matter where I am told by my other side, I was not there last Tuesday, my personal reason, it's been adjourned for a week, apparently. That's what my lord had.
It was adjourned for a week.
It was adjourned for a week. Your lordship,
So-
will recall, my lord, Mr. Gupta, Choyan Gupta was appearing physically.
Yes.
Mr. Anirban Rai was there virtually.
Need not remind us anything. If you say it was adjourned for a week,
In fact, both of them are there virtually today.
if it comes from the bar that we had adjourned for a week, that is sufficient for us. So then when did you keep it?
If they're wanting for next Tuesday, my lord.
We kept it on next Tuesday.
Because at that time, lordship was taking up assigned matters only on Tuesday.
No, what is
My
it
lord,
recorded in the order?
Not this
I
week.
was not there.
Mr. Rai, was it recorded in the order?
No, my lord, there was no recording, my lord. This
If
time
there's
your
no
lordship
recording,
is
can we take it up on Monday? Can you keep it on Monday? Because we are short of matters now.
Monday, the other matter which was mentioned by Mr. Bhattacharya,
Well,
will
Monday-
have time, but after that,
Yeah,
we'll
Monday
happily
to-
do it.
Quid pro quo.
Yes, my lord,
No,
I'm okay
let
with
it be on
Monday. If your
Monday.
lordship
Let it
can
be on
keep it
Monday.
Let it be in the list on Monday, Mr. Rai.
Monday,
and
Monday. Yes, my lord, Monday.
Any difficulty?
Tuesday, I might have some problems, but Monday would be very nice. I'm very grateful.
Mr. Gupta, I hope you'll be back on, you'll be here on Monday. Mr. Gupta? Yes. These were personal
Yes,
things.
sir. Oh, acha, acha. Let us keep it on Monday.
Monday I'll do it. Monday, even if he's, I hope he'll be there. I'm sure he'll be there.
When the matter is called on for hearing, it is pointed out by learned counsel that that previously we had expressed an opinion that the matter shall be adjourned for a week, so accordingly let the matter stand over till August 11, 2025.
Grateful.
Grateful.